Can you hear me?
Yeah, we can.
Welcome to a meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I will begin by taking roll. Hartston.
Here.
Kirkmeyer.
Here.
Sarouche.
Here.
Okay, and we are well met. And I don't know if we wanted to start with the discussion of the rules. I sent out.
Should we see if we have any public comment?
Oh, yes, we can do that. So there are 8 members of the public in attendance. If anyone wants to make a comment, please raise your hand in Zoom. I don't see any comments, so any raised hands? Okay.
Okay.
So I'm just wondering, do we want to start with the discussion of proactive regulation or of the rules that were brought forward? I forwarded everybody sort of the Andrew Tuft's comments on the rules and suggested changes as well as drafts. So do we want to take that first? Sound good?
So it's the easiest, right, to finish those out?
Yes. Yeah. So I'll bring up first 1.4 and Randy was gonna speak to these. So let me just share the first one. Make it a little bit bigger. Can everybody see that?
Yeah.
Okay.
So Randy, are you gonna
Sure.
walk through? Okay, thanks.
Okay. Rule 1.4.1 is the communication settlement offers rules. It, taking a big step back, it reflects the fact that in the common law, the case law with regard to attorney professional responsibility, there are certain things that are within the authority and sphere of the client's authority and things that are within the authority of the attorney. And so procedural matters, non-substantive matters, scheduling a deposition, et cetera, are all within the authority of the attorney. The attorney can bind the client to those decisions, but the case law is clear that matters such as a major substantive issue, such as the decision to settle a case, is completely within the authority of the client. And the rule that requires an attorney communicate an offer of settlement is intended to facilitate that dynamic, that the lawyer can't decide settlement, the client has to. And so the rule says if you get an offer of settlement, it must be communicated. The rule that was proposed and what we looked at with the full working group omitted part of the definition of a client because it was a concern that the client is supposed to be an individual and not an entity. But this is, I think, a classic situation where the baby went out with the bathwater, because the definition of client in the attorney rule is broadly stated to include anyone who possesses the authority to accept an offer of settlement. And that could be something as simple as your client is out of country and appoints their relative to be attorney in fact, it's in the power of attorney to settle the case. And so Ira noted this, and Greg, Randy, Andrew all exchanged emails that, we're all in agreement that that language should be restored. And the way to address the issue of whether or not this might create a misleading impression that somehow paraprofessionals are entitled to represent entities, we think a comment can be added. And the comments are all sort of being held in abeyance for now until we get through all of the black letter rules. We'll go back to the comments, but we would put a flag on this to go back and add a comment that makes clear that while the definition of client here includes perhaps another person or entity authorized to settlement, Maybe it's the client's employer where they have tendered the representation to the employer, or an insurance company. It could be an entity, but it doesn't mean we're undermining the policy decision that's been made that paraprofessionals shouldn't be representing entities, they should be representing individuals. So the comment would be to that effect. But in terms of black letter, we would restore to the rule that part of the definition of client that includes authority, a person who has authority to accept settlement. We wouldn't put back the part about pleas because we don't have criminal or class actions. Those would still be stricken from that definition that's in the attorney rule. So that one's pretty straightforward.
Does anyone have any questions? I have a very embarrassing question, but this, what we see on the screen, it does not reflect your proposed revisions, correct?
It does.
It does.
So it's
Yeah.
paragraph B, as used in this rule, client includes a person who possesses authority to accept an offer of settlement. So that's the part
Okay.
that came back in. So
Okay.
we're good if that's there.
Does anyone, Freba or Amos, do you have any issue with Randy's recommendation?
No.
I agree. I'm hoping Randy will be able to present at the full working group.
Yeah. Okay. Should we go on to 3.5? Randy?
3.5 is the rule that governs contact with judges, including judicial employees, other officials, et cetera. And it prohibits ex parte communications. It's a fairness rule for the adversarial system in terms of resolutions of matters before a tribunal. You don't want one side having a private caucus with the person who's going to be deciding the case, or people closely related to the person deciding the case. But there is an exception, paragraph B. And what was noted at the working group meeting was that some of the subparts of the exception had been stricken, in particular, the exception for communications with the judicial officer in open court or in the presence of all other counsel. And those were not intended to be removed from the exception. What was intended to be removed, and I think it just might have been a scrivener for issue with regard to the version that was ultimately distributed to the working group. But Greg had noted that in the versions that we were all looking at prior to the working group meeting, those things were supposed to be retained. The intent was simply to excise the parts that dealt with appearances before a jury proceeding. So a proceeding before a jury, we wanted to knock those out, any exceptions related to that, et cetera. But we wanted to retain the provisions for exceptions, the ex parte communication prohibition with regard to in open court, with the consent of other counsel, in the presence of all other counsel, and in writing with copies furnished to the other counsel, because those would apply in the limited settings where the authorized practice of law for the paraprofessional included appearing in a judge trial. And so those are all pretty straightforward. The one that Linda mentioned, and I'm glad she mentioned it, is B5, which goes to in ex parte matters. And so Andrew, Greg and I, we didn't really address that one, but I believe, I would almost be certain that our approach to that would be that if there are actual tasks that are authorized for paraprofessionals that include an ex parte appearance, then that exception needs to go back. But if there are no tasks whatsoever for any of the categories of paraprofessionals that allows for an ex parte appearance, then we don't need the exception. So that one, somewhat of an open issue because I don't know the answer to that question, but the other parts are perfectly fine to be restored. They were supposed to be in there in the first place, I guess.
So.
Yeah.
Different courts handle ex partes in different ways, also different divisions in different courts, right? So in our court, well, civil has a ex parte calendar. We don't have one in family. It's all on paper. Okay, so just talking about family law, I can envision so there is no, it's on paper in our county. I know there are other counties that do have ex parte calendars for family as well. So while there are certain ex parte tasks that are excluded in family, there are some that are allowed, like order shortening time and things like that. So I'm just thinking there may be situations that they're in tasks that they're allowed to perform, that there may be some ex parte aspect to it. So I mean, it would probably not be wise to exclude that. If you're authorizing to perform the task and handle that issue, then we have to kind of let them have access like that.
Yeah, that's what I was thinking. In family law, it's going to come up.
And in the UD context, when they're applying, when an eviction has been ordered and the tenant comes in to apply and notice has been posted by the sheriff, then there's a stay process that has an ex parte side to it. And in our court is a hearing. So I believe that I'm on the housing subcommittee. I believe that the way we worded our proposal, we have allowed them to help with a stay as part of a UD case.
Okay.
So does that look right now? Just we've restored that.
Yeah.
Okay. And the last one was the one that Stephen Fleischman had brought up, just having to do with the name of this rule, the title for the rule.
And I'm not sure that the recommended changes actually address Stephen Fleischman's comments, but I could be wrong. I think he has a problem with the word law practice. Even adding paraprofessional law practice in front of it, I'm not sure it's going to address that, but I'd like to hear from Amos and Fariba if that's kind of your thought of what he was coming from, or Leah or Linda, anyone.
Yeah, I agree, Kim. I'm not sure that addresses Steve's concern.
I mean,
I just want to say the same thing. And we may have to kind of in the queue. Okay, sorry guys. We may have to just wait for the discussion to really get a better idea of what he's saying.
So Kim and Amos and Randy, how do you understand his concern to be different?
I thought the word law practice is what he's having issues with, not to put, I think in the title, and it sounded like it was only in the title from what I read that he had sent. It was in the title of law practice, and I don't know if just by changing it to licensed paraprofessionals law practice, if he's going to be okay with that, or even the way we have it written in that first sentence. I think that's what he has a concern with, but I think we have this throughout all, I mean, there's probably other sections, I'm assuming, that says law practice, but I didn't do a search in the document, but.
Well, if they're being licensed to practice law, isn't it a law practice?
That was
Yeah, I
great.
think the issue is also with the term law firm, but I agree. I think I don't agree with this concern, but I think the idea is licensed paraprofessionals that join together and form a firm, I think there's a concern about calling that a law firm. Is my understanding of the concern that was raised.
So let me mention that in the rules that have been proposed, the terminology rule 1.0.1 does define the term firm and the term law firm. It's 1.0.1c, and it's defined to mean a licensed paraprofessional, lawyer, or lawyers in a law partnership, professional law corporation. And so it actually covers the scenarios that could exist, whether it is a reference to a law firm, which is a traditional law firm, or a reference to a law firm or a firm which is comprised of paraprofessionals and lawyers, or a complete paraprofessional firm. The defined term, firm or law firm, at least the definition we have now, reaches all of those different variations. And when I look through the other rules that we have, there were 3 instances where the term law firm was qualified as being a licensed paraprofessionals law firm. And so you have the rule 1.8.5 that deals with payment of a client's personal expenses. And it says that a licensed paraprofessional shall not pay, or the licensed paraprofessionals law firm shall not pay the personal expenses of a client. So in that instance, the defined term law firm was qualified as being licensed paraprofessional law firm. And similar treatments are in 1.8.9, which is purchasing property at a foreclosure or judicial sale. And also the trust accounting rule, rule 1.15, all funds received or held by a licensed paraprofessional or, quote, a licensed paraprofessional's law firm must be placed in a trust account. And so the suggested response to Stephen's concern was to use that same qualification that is apparently being used in other rules to make sure that this use of the term firm or law firm was really intended to describe an all paraprofessional law firm rather than a traditional attorney law firm. So sale of a licensed paraprofessional's law practice could be sale of a licensed paraprofessional's law firm, or if you even wanted to make it safer, maybe sale of a licensed paraprofessional's firm, if you don't like the word law. But I think you can use the qualification of licensed paraprofessional to modify law firm or firm in a way that tries to communicate to the reader that we're talking about a sale of a paraprofessional practice, not of a traditional law firm.
And the other thing where I think this might actually satisfy his concern is when I asked him if he had alternative language, he said his only concern was with the title. And if you read the first line, it says all or substantially all of the law practice of a licensed paraprofessional. And he didn't object to that. He specifically referred to the title. So I think this might actually satisfy him.
Well, let's give it a go.
Okay.
Okay, so those were our outstanding items from the last meeting. Linda, have you been able to schedule the August meeting?
Well, I just got 2 more votes today, so it looks like we're going to do it on the 16th.
Okay. And that will be a rules dedicated meeting, and hopefully we get through, I think, what is it now, 13 that have been pulled out?
Yeah.
Pulled out for individual votes.
Okay.
Okay.
Linda, just so you know, I can't make the 16th, or at least not the full meeting.
Okay. Yeah, it was really hard. It's evenly split. 10 people could make one, 10 people could make the other. And there were a number of people who couldn't make either of the dates. So that's what we're going to do. Okay.
What time to what time on the 16th?
I don't, Leah, do you think we need to have a full 6-hour meeting? We should schedule it. And if we
Yeah, I
can
mean,
get
I
through it in
don't know
less
what you
time.
guys think. We have the 13 or 12 rules to get through. I could see it taking a long time. There's gonna have to be, and this will have to try to work on with OGC and Justice Petru, but some kind of process for moving things to a vote. You know,
Right.
just an up or down vote.
Right, and on that day, we may also, we're gonna have the sort of the consent calendar again, and there may be more items that are pulled out, because
Well, I thought we
people-
voted on, didn't
No,
we vote?
Yeah,
we
we voted
didn't.
on the consent.
We did or we did not?
We
You
did.
did.
Oh, we did. Oh, okay. Why am I thinking we didn't get to it?
Oh,
We did.
God, for Reva.
Oh my gosh. Okay, I'm less scared now.
So
Okay. So do we have, so are the new ones we discussed today, are they assigned for discussion to Randy? I vote yes. Or
Yeah, I
or
think
is it
that's
one of us? I
fine.
don't mind.
No.
I just,
No, Randy can do it.
okay.
Right, Randy?
Yes, I just checked 16th. I will block it out,
Yeah.
whatever the time is.
Okay.
All right, so we have a proposal for today because I think we are, dare I say it, done with the rules for right now. But we have other to-dos for this subcommittee.
Okay, so I can share what we've prepared. So can I leave this for you to lead this discussion, Leah?
Sure, that we're getting back into proactive regulation. So all that we've done is try to pull together notes from our last several discussions on this. And the hope is that today we will figure out collectively or hear from you how you want to move forward. So we have here some of the risks. There was Linda, was there an additional risk that didn't make it onto this slide?
Yes, there was an additional risk that we decided, I think that the subcommittee decided not to include, which was the risk that you'd have a worse outcome than if you use the next best option. And there was a decision made early on to not include that.
Okay.
So
Okay.
these were the ones that were decided to include for consideration in proactive regulation.
Okay. So here you see the three primary risks, and then if we go to the next slide. Some of the tools or the ideas that you all came up with in terms of how to address those risks proactively. And some of these are obviously more easily implemented than others. But this is essentially where we left off. I have a document with a lot more verbiage on it, but this is the nitty gritty of what you all came to. Linda, is there another slide? I can't recall. Okay,
So there's a slide that provides a little bit more information on each of those high level descriptions.
Okay, good. And with all the language, I was thinking, this is what happened to all the language? I forgot there were additional slides. Okay, so you can keep going. Hopefully this is ringing a bell with you all.
I think for me, the self-assessment was something we discussed, but we raised concerns about the burden, and it was in connection with what the evaluation was going to look like. So I think this is one that we put a pin in and didn't decide yet to move forward. But I do think it does make sense, and we just should consider it with the burden, especially in connection with the evaluation.
Okay.
Has everyone had a chance to read this slide? Should I move on?
May I ask, are we commenting on every slide or what are we doing? We're just going through them and then have a discussion?
Sorry for you, but I wanted to go through them and then to come back perhaps to the one slide that just shows all the different buckets of potential proactive regulation measures. Because I think your task is to come up with a recommendation for the full working group to consider. Not I think, but that is your task. With respect to the proactive regulation framework. And it is different from the evaluation, but obviously complementary. And as Amos notes, when you sort of consider both what is going to be required of the paraprofessional for evaluative reasons and what we're going to require for regulatory reasons, you have to start thinking about the burden on the licensee. So we can do it slide by slide if you prefer, or just run through them and then go back to it. I don't have a preference.
Yeah, it would be helpful to run through them, but then go back to the expanded slide, not just the one with the umbrella categories.
Okay.
Thank you.
And I don't think I was on the committee when they were discussing these, so this is helpful for me to see them all.
Okay, all right, good. So the ethics hotline and online resources, this is something that we have in place for attorneys already. So this would be replicating that model for paraprofessionals. So case file review, this is probably the most invasive and labor intensive aspect of or option that has been identified. And really what you'd be looking at, there's two things you could look at. One was the right outcome achieved, however that would be determined. And the other would be, was, this I think goes to Linda's first comment about a risk that was dropped, but was an outcome achieved that was as good as the next best alternative.
And what would be like a triggering event?
Well, what was identified, and this was, the reason I did the shorthand is on an earlier slide, it talked about a triggering event could just be some contact with the discipline system. So a complaint that came in, but that didn't rise to the level of discipline, but maybe is something that would be helpful for the paraprofessional to get some feedback on.
Got it.
And this is the last one. The question about client surveys and satisfaction and feedback, but the real question is how would we go about administering that kind of a survey?
And are they already, oh, sorry, Leah, go ahead.
That's a direct overlap with the evaluation, right? And the distinction perhaps is, I mean, we haven't really talked about this, but the evaluation being one time. So perhaps there's an evaluation done during the pilot phase and the evaluation results are used to determine whether or not the program should expand, just for example. Whereas the proactive regulatory measures are going to be in place in perpetuity, presumably. They might change, but it is part of the regulatory framework. It's not finite in term. So were you going to ask?
I do have one more slide.
Yeah, this goes to what I was just saying, that it will change. And this, I think we got like some really helpful suggestions from Tara Sklar about how you use data you get to then further refine the data you're asking for. So maybe we can start off, we can go back to individual slides, but is there anything conceptually that's missing? So we're talking about sort of additional supports through things like MCLE and the ethics hotline. We're talking about feedback through like client surveys. we're talking about some kind of quality assessment, sort of objective through a case file review. And self-assessment is both a training tool, but also it's a training tool and a way to get input, to get insight into how these practices are going. So are there things when you think about information we might want to regulate the program that are missing from these kind of buckets that have been identified?
So I'll go first. So if
Yeah.
I remember our discussion correctly, so we sort of, I'm taking a look at the slides. So the source could be the paraprofessional, clients, and then there's the state bar with regards to case reviews and CLEs and so on. So we've got those sort of sites covered, and I'm just wondering if there's a site we're missing that has information, like a source of feedback and information. Clients certainly do, and I have some suggestions about that. Yeah, paraprofessionals do, but you know, are they gonna, how honest they're gonna be about the system themselves? I don't know. And then having the state bar do case reviews so so labor intensive. I don't even know if that's realistic. You don't do that. Do you do that with attorneys?
No.
Yeah, so this is so labor intensive. I'm just wondering if there's a source of information that is not as onerous on the state bar, that is neutral, that we could rely on. I'm asking that because I can't think of one.
What about the judges in the court?
So I think we talked about that. It's just that it's a resource issue. So while we can encourage it, in my opinion, while we can encourage it, we can't mandate it. And I speak about that from experience from just all the projects I've been on. And that's a fantastic self-help centers. Yeah, you know, if there's an easy way, if it's okay to do it, there's an easy way to do it. You know, I've had so many issues this week. I mean, if we had the systems in place, would it be appropriate for me to, or for my staff to make a report? I don't know what's the threshold. I don't know if it's, you know, my court would let me.
What do you mean for you to make a report?
So, you know, when we come across paperwork that is definitely done wrong and we pinpoint it because we're experts, right? We know. And we know that the litigant tells us they paid, we see who, it just happened that the person had their stamp on there. Let's say we, you know, 2, 3, 4 years from now, when this program is launched, if something like that happened, would I, as an employee of the court who see the paperwork, have talked to the litigant, be able to report that? How would I report that? Would my court allow me to report it?
Well, they should, right? Because you could report an attorney now to the state bar.
I think, well, we don't come across attorney work, but with the judges are able to do that, right?
Yep, judges do, court staff do.
Yeah.
And it's kind of like a fine line, right, between a complaint and something that's meant to be like proactive regulation. I guess you could also say it could come in as a complaint and it's not going to merit, you know, disciplinary action. And so it kicks it back into the, like, it's a triggering event.
Mm-hmm, mm-hmm. I had previously, Leah, I think I emailed you and maybe Linda too about, you know, we have live chat here and there's a function there where people can use that service after the call is or the conversation is terminated, can review it, right? And so it's an automatic thing. I go in there, I can kind of, it's a dashboard, really easy to check. There's absolutely no effort on our part to maintain it, but the data is available to us and it's pinpointed to the staff member and everything. So I have all this at my disposal for training purposes. I look at the details and I'm able to decipher, for example, sometimes they just don't get the answer they want. I do that work myself too. Like I was doing it this morning. The person reached out to us a question about jury duty. Our office doesn't handle that. So I gave him the link, but he gave me a thumbs down afterwards. So, so I can look into the reason for the thumbs down and all that and verify that it's a legitimate complaint and, kind of in using it to train my staff, right? So I was thinking, some online tool like that where it's clarified that this does not automatically result in a complaint to the state bar, but people can go on there and review a paraprofessional by providing the name, the license, the date of service, what happened, specific, so that it's a tool available. And then you could have an automatic sort of way to measure the number of complaints that comes against a certain paraprofessional, and it passes like 100 in 6 months, and it sort of sends a notice to whoever's monitoring to say, a warning, this person is getting so many negative remarks, and that could be a triggering event for the state bar to sort of take a look. And because you're asking for specific information about the name of the licensee, license number, your name, what happened in your case, why are you complaining, kind of like taking a look at it to make sure it's not an example of a thumbs down I got today. Is it a fair complaint? And I'm just putting this out there, in terms of brainstorming, but it's a way to sort of have that information at your fingertips. At the same time, the clients don't get the idea by just putting in the comment and, the comment on this online resource that is going to automatically turn into a complaint. That if they want a complaint, there's another way to do it, to start an official complaint process, but that the state bar can use this tool to.
How would a client decide whether they want to do a formal complaint versus, and how would we, if we're describing it as an available option to provide feedback, how would we distinguish it? My concern would be that it might encourage people to say, oh, I don't know really if this is a legitimate complaint or not. I'm not sure which way I would go. And so there might be something that really should be filed as a complaint. I don't know that we want to have two different portals. Like either someone is dissatisfied in making a complaint because they think there was something wrong, or they're not. I don't know. Do any of the DCA boards have, I know you can go and file a complaint online against licensees with all of the boards, but I'm just wondering if there's something akin to what Fariba is suggesting.
No, we would treat pretty much everything coming in as a complaint. That's what I'm saying. It's kind of a fine line, and you'd want to make sure you look into everything, on our side.
Yeah.
But yeah, there's nothing where it's not to the level of a complaint. I mean, that's almost like Fariba's kind of talking like, yeah, almost not to, think that like it's almost like a Yelp, right? Fariba, kind of like, where you kind of rating almost a little bit.
But does the state bar, if something like that were to be provided, let's just say, okay, does the state bar have to make it available for viewing by the public where they could pull up a license? You can't do that with attorneys now, right?
Right. Complaints against attorneys are not public unless charges are filed.
Right. So I didn't mean for it to be available for the public at that stage anyway. It's just a tool. It's just an assessment tool by the bar, for the bar.
The one thing that I see that is happening like on our side kind of is that, the normal continuing education that everybody's used to, of, you know, classroom sittings, and, you know, sometimes you'll have like a little quiz at the end or whatever, and you have to attend it for so many hours, whether it's online or you're in person. That's kind of somewhat changing. There's been kind of a movement to change that into more continued competency for individuals, where it kind of feeds into some of the things you already have, like encouraging individuals to do a self-assessment, doing more examination. I think there's some things called like mission moments. And some of this has been kind of some of the boards that certify different individuals, they've been moving into that kind of movement. And so there's a lot of different opportunities that they've been pushing for their individuals who are certified with them, to get away from that old fashioned, you know, what they're saying is old fashioned continuing education format. There's a lot of talk around that.
So Kim, do you think about that in terms of like both the MCLE bucket and the on the self-assessment bucket? Okay, but
Yeah.
let's since we're talking about client feedback, so I've always assumed that we would want to get this, but you're raising some interesting complications, everyone. Like if the state bar is soliciting this, and it's not, we want feedback, right? The feedback might be really positive. We don't know what the feedback is, but you certainly don't want to confuse the consumer. Like I wrote this terrible review of this attorney, and nothing happened, right? Well, that isn't because it's a totally different lane from our discipline complaint lane. And that creates more confusion for the consumer. So then when you were talking, I was thinking about, well, what if the paraprofessional is required to send their clients a link to an online survey? And the state bar has access to the data, but it is the paraprofessional distributing the link, and we can assess the data. So what we're regulating is that they're providing their client with the link.
And how would we confirm that that's happened?
I don't know. Well, how are we going to confirm anything that's happened, like our informed consent and our disclosure? Yeah.
Or probably when a triggering event happens, that would be one of the things that probably you want to inquire to if you actually start, you know, looking into it and interviewing the client and interviewing the paraprofessional, and you discover, you just send that link.
Yeah, the link could also be on the informed consent. It could be on in the fee agreement. Any thoughts, Randy, from a regulatory perspective?
Well, I'm not sure if disclosure and education is, I guess I would put that into the broad category of proactive regulation and gathering information. But I do think that the self-assessments would probably be the most targeted way of doing the exact same thing, because you have a little bit more control over laying the foundation for what the user will actually understand and be able to respond to when they're asked questions. And the questions and the answers, if you get enough of them, would be a reliable source for drawing inferences about what that population knows and what type of regulation might respond to any lack of knowledge or any, you know, misunderstandings about the regulatory system. So everything we've sort of been touching on, I kind of lean towards the self-assessment. Maybe it's because I did a whole thing on that recently for the board that my mind is sort of fixated on that. But when I think about proactive, I think you'd like it to be data-driven. And some of these things, even ethics hotline stats, it's really just whoever happened to know that they could call and actually get help. And for the ethics hotline, we learned through overall the years that it's really the small and solos who seek our services as opposed to the big firms, because the big firms have a culture where, you know, if you have an issue, particularly legal, ethical issue, don't go outside of the family, stay within the firm. And so even ethics hotline stats, unless you know, the paraprofessional world is different from the law firm world, you know, might not have you know, the best amount of data to work on. But I'd be hopeful that self-assessments would, because if paraprofessionals have an MCLE requirement, the way we entice them to use the self-assessment is to offer the MCLE credit.
So is there are self-assessments being developed for attorneys, right?
Yes.
Yes.
Are those confidential?
Last
Does the
July,
State Bar get to see each individual attorney's self-assessment?
yeah, last July, the board said we should offer it in a way that the users have a confidential option. And so we are working with the vendors to assure that if someone chooses to have their self-assessment answers confidential, that they have that angle. And so IT staff has used something called Qualtrics for some surveys, and Qualtrics has a very robust anonymity. It even masks the URL IP that you use to access their page. So, you know, that's probably the best, because when we looked into our own LMS, a learning management system, we found that, you know, you can find out who's there because that's the actual portal, My State Bar Profile, that actually gets you into it.
Right.
But it is sort of a challenge. The way Colorado dealt with their self-assessment is that they got a rule of court that says the information collected by the bar can't be used against any of those attorneys. And so rather than try to wrestle with keeping it 100% secret, they said, well, if anything is found out, obtained through public records or anything else, it still can't be used against the attorneys. And that's their way of dealing with the chilling effect of using the self-assessments.
And I think that, I mean, there's two potential uses for the self-assessment, because if you want to do it based on an individual response and give that person assistance, I think if people are providing information that's not, not even so much confidential, but anonymous, I think then you risk not getting honest responses. So if you make it anonymous, then you can look at the responses in the aggregate, and hopefully people are going to be honest in completing their self-assessments. You have this aggregate information that's hopefully more valid, and you can use that to develop outreach and to provide tools broadly to say, this is what we found, as opposed to targeting individuals.
Yeah, I think it's the challenge with the regulation, because when I think about the distinction between evaluation and regulation, I keep coming to, if we're regulating, at some point you have to have the ability to reach back out to the specific licensee. And so like an anonymous self-assessment, it would give us as the regulator data, like we'd be able to look at, okay, 2,500 paraprofessionals completed their self-assessment. It's anonymous, but we do have the ability to see the results. I think we have to be able to see the results. And we see that 60% of them are answering this ethics rule question wrong, right? Or 90% of them. That tells us we need to push out a mandatory 15-minute training on this particular rule. So I guess that's how it would work on the anonymous side. If it wasn't anonymous, you could go in at some point and say, hey, Attorney Leah, we've watched your last 2 self-assessment cycles. You're really getting a lot wrong here, and we're going to mandate now that you go through a course. And yeah, so I don't know. I don't know what's the right option.
I guess it depends on what's included in the self-assessment, because I thought some of it was going to be practice management things. And so I think if the questions are about practice management or other things like that, where it's not that there's a right or wrong answer, they're just saying what they do. They can just lie and say, oh yeah, I'm doing all these things that are best practice. It's different from like having questions, you know, where you're sort of testing them on their knowledge of ethics.
Yeah, so what types of questions are on the self-assessment? Sorry if I should know and I don't know.
No, Randy, I don't know if you have the ability to pull up. Do we actually have a draft of our CTA?
Not yet. And so
Okay.
just give you an example, in a normal sort of distance learning, e-learning course, let's say it's about trust accounting, you know, we might ask people, do you know the difference between an IOLTA account and a non-IOLTA account? You know, do you know when you have to use one over the other, when the interest should be collected for legal services, when it should be collected as a fiduciary and in order to the benefit of your client because it's a big amount of money? And so that would be all substantive knowledge about your trust accounting duty. But then the self-assessment would add a different dimension. It would ask the person directly, and this is sort of getting at the person's practices. When you open or close an IOLTA account, do you go into your My State Bar profile and give notice to the IOLTA department so that they know? Because the IOLTA department has to pay all the fees on these IOLTA accounts, and they are tracking who has IOLTA accounts, if there are unproductive IOLTA accounts. And so some attorneys, out of an abundance of risk management, even if they're not holding funds regularly, they'll just have an IOLTA account. And instead of that money, that account collecting interest that's feeding legal services, it's just actually taking money to pay the fees for the account. And so IOLTA monitors that, and they try to get attorneys to close that account. And so, like Leo was saying, if you have a non-anonymous self-assessment and you have attorneys saying, well, I thought it was a good idea to have an IOLTA account, even though I'm not regularly holding money, we can go back to those people and say, it's actually not a good idea because they're actually taxing the system by the fees on those accounts for the year. Only open it if you really are holding money. And if you are, that's great. So that type of direct improvement to the best practices, the behavior of the practitioner is what you get if you know who they are and you're asking questions about what they're doing.
Can I just ask a clarification or two, actually? So for the self-assessment for the paraprofessionals, what is the outcome of that? Because it seems like there's several things that we're thinking of. Is it to analyze themselves to say what they need further training in? Is it to gather information about, you know, what the whole unit of paraprofessionals might be missing? Or is it an individual self-assessment about what an individual, where they need to improve themselves? I guess the first and the third are kind of similar. And then what's the state bar one that you're working on for attorneys? What is that one trying to do?
Well, the state bar one is a series of self-assessment modules. They were all, the main topics were inspired by the Colorado program. And so we have things on client trust accounting, fees, fee agreements, fee disputes, conflicts of interest, opening a case for attorney-client relationship. And the first one that the board wanted to do is client trust accounting. So that's the one that's in progress. And I think the idea with paraprofessionals would be analogous, particularly since we had this whole set of paraprofessional rules, as well as the specific limitations on the license for the specific categories. I think it really would be helpful to have a self-assessment almost for each category of person, so that the individuals will know where their weaknesses are in understanding, and where we can look at that data and say, well, we went with the approach of adapting the ABA rule on fee sharing for paraprofessionals, but no one understands it out there. They're all getting that wrong. Who knows what they're actually doing out in the wild? We might need to revisit that because it doesn't appear what we intended is actually working. And so I think self-assessment could reveal a lot of those things.
But I think like the primary impetus for the attorney self-assessment modules is like self-improvement,
Yes.
awareness and self-improvement, right? Secondary is the state bar to gather data to inform future educational and perhaps regulatory efforts. Some challenges or things I think should be modified for the paraprofessional context is the self-assessments we're developing are not mandatory, right? So I think on the paraprofessional side, if this is regulatory and part of proactive regulation, I think they should be mandatory for starters. Then there's this whole question of anonymity, but at least you'd have to do it and you'd have to match up. Well, we've got 9,000 paraprofessionals. We need to have 9,000 self-assessments. Otherwise, somebody didn't do it. So, and then there's that other step of, is the purpose potentially disciplinary? Like A, because you didn't do your self-assessment, but B, because we're looking at it would have to be over time, you know, you're still getting all this wrong. So at some point we come in and say, you can't practice anymore. And that seems like a stretch, but those are the different options that I see for the self-assessment.
In terms of mandatory for attorneys, we do have the 10-hour new attorney training program. So every attorney who's admitted within their first year of practice, they have a special 10-hour curriculum that's mandatory. The rest of the 25 hours that they can take for the rest of their 3-year compliance period, they get to choose. But in that first year, they need 10 units of a set curriculum. And it's not a self-assessment because we don't ask the questions about what they're doing. It's really just testing their knowledge. But mandatory education is something that the bar has, at least in regards to the new attorney training program.
Amos, I don't know if I know you said you were, I think, in transit, but I don't know if you have thoughts on this piece. It sounded like you did have thoughts on the self-assessment. Because I thought we had gotten pretty far along with Terra Scalar, and I don't remember, Linda, if we were, I think it was mandatory after the first and third year of practice. Maybe you can put that slide back up. I think Amos is not actually able to join us right now.
Yeah, I am here.
Okay.
But I think I have a different view of where we were on the self-assessment. I know it's something that the staff is very in favor of, but I have concerns about the burden. And so I think we just put a pin in it. I'm happy to continue to discuss it, but I think it really depends on what it looks like and really what the self-assessment, not only the self-assessment, but what the evaluation and how much burden we're placing on the paraprofessionals in data collection.
Okay. So of the like the buckets that we've gone over, what are you in favor of? You know, MCL, you know, we talked about MCLE, case file review, the ethics hotline, the client surveys.
Yeah, so if you remember, I sent around an email with suggesting a lot of these from the written materials that were happening in other states. So I'm in favor of all of them. The MCLE and toolkits and ethics hotline. I think client surveys could be very valuable as well. I think the file review and the self-assessment is just, I have concerns about implementation, burden, privacy, and those sorts of concerns. Obviously, the information would be helpful, but we just have to sort of play that out a little bit more and really see what we're talking about, what the burden and obstacles would be.
Leah, can I mention one thing that's not on the list so far?
Okay.
Andrew sent around a notice about at the ABA annual meeting in August, they're going to be considering changing the model standards for lawyer referral services that the ABA has. And in those standards, they acknowledge that some jurisdictions are licensing paraprofessionals. And while traditionally a lawyer referral service has only assisted a consumer in finding a lawyer, the new model standards that have been proposed by the ABA would modify it to include referrals to paraprofessionals if they're licensed in that jurisdiction. And I put that sort of out there because, you know, the reactive or complaint-driven angle on referral services, that you don't want paraprofessionals to be paying cappers as a way of getting cases. But if you have lawyer referral services expanded to cover paraprofessionals, then they could join up with an LRS and lawfully get the clients the right way through the lawyer referral service. And so it's something I think to consider, because we do have a good lawyer referral service program here in California. And if the ABA is already thinking in those terms, I can't think of anything that would be particularly bad about considering that, aside from the resource issues of having to regulate an expanded LRS program.
The other thing in terms of that is that LRS is routinely send surveys to clients to whom referrals have been made. So perhaps in the I don't know how comfortable they would be with sharing the client surveys that they get. And I don't know what the rate of response is, but I think it might be worth working with those programs, and maybe that would be a good source of information.
Okay. Well, I'm looking to all of you as to how to advance the conversation. It sounds like for the MCLE and toolkits, I mean, I think that's non-controversial. I think, Kim, you're raising kind of this overall question, which is very live in the attorney context as well, is like, what's the value of the traditional MCLE, right? Toolkits is something that I don't think we do much of currently on the attorney side. But that doesn't seem to be sort of controversial. Opening up an ethics hotline for paraprofessionals seems to be kind of an obvious one. So it sounds like the more challenging areas are the self-assessments, client surveys, and the case file review. And Amos, if I'm understanding you correctly, you kind of want to think about those in the context of what's going to be required for the evaluation, or at least some of these. So I don't know if that means, in your view, holding off on this conversation until the evaluation framework is done. I don't know, Fariba and Kim, if that's also how you want to proceed. I just kind of want to figure out how to move this conversation forward.
From my perspective, I agree that case file review, that's going to be very resource intensive. And, you know, again, it's going to be a struggle, because what if you get into some case file review and you find out that, you know, there's reason for discipline in those? It just seems like a difficult one to me. But I agree with you. With that stance, that MCLE and the ethics hotline, those are great resources to move forward.
Okay.
I think if there is a triggering event that raises a very serious consumer protection issue, then the state bar can put resources behind it. I'm not sure if the case file review is put in there like random case file review, because if you open it, it did say one of the instigating events was a triggering event, but then there were two more. No, next one. Yeah. So random review, I just think that's way too expensive for you all. Periodic review, again, that also falls in that same category of resource intensive, but triggering event would be probably reasonable depending on how you define triggering event. And it may make it worth it to go in and review specific case files. I'm assuming you're gonna reach out to the licensed professional and whatever the framework is, and then ask for access to their case files to review them. Is that correct? Or is that what the thought?
Yes.
Okay. So I think then it would be worth it, right, to spend that kind of effort. But nothing random. I just think it's just unrealistic in today's world where everybody's budget is, facing budget constraints. I do, based on what I see, I really do think there needs to be more information out there, like public outreach to let the public know what consumer protection tools the state bar is providing when it's launching this new program, right? And from what I see now, people, when we explain to people what has happened and why, and then they tell us, yeah, I spent so much money. And we explain to them the options available to them right now in the current structure. They just prefer to just kind of be at peace with losing the money and doing things the right way from here on. But I just think that if you're starting this new program, you should really think about how to provide easy access for the consumers who happen to deal with a bad actor who has a license. And that's why I was suggesting the online, for lack of a better word, review. Thank
So
you.
for triggering event, I'm a little confused about that because this is not being considered as part of the disciplinary system, right? So this is separate from a complaint and discipline where there are due process rights and there's a hearing and, it might be contested whether the complaint has merit or not. So this would have to be something, I assume, voluntary. But again, it's unclear. I think there's a lot of hurdles with privacy and attorney-client privilege and things like that as well.
I thought not every complaint turns into a charged case, right? However, whatever terminology you use, right? So there are complaints that don't go anywhere, right?
Right.
But
we'd have to get new authority. I think that's absolutely accurate. If there's going to be, let's say a triggering event is you've had 5 complaints closed in intake, that means that it's never been public. And under our current system, which I don't know if we're going to do the same thing with paraprofessionals, attorneys who get complained about and those complaints are closed in intake, they're not even noticed that somebody filed a complaint against them. So let's say though it was 5 complaints, that was a triggering event for a case file review to see, like, I want to know a little bit more about what's going on in this practice. Nothing meets this burden or meets the level of a disciplinary to invoke a disciplinary action, but there's something that feels off here. That would be like the application of the triggering event, and you go in and start looking at case files. And we don't have the authority to do that on the attorney's side at all. We'd have to build in that authority if that was what we wanted to be able to do.
that's kind of what I had in mind. So I don't know if it's realistic to even wish for that or ask for that. I don't know if it's going to get any support, encroaching on certain rights.
Yeah, I think the privacy concern is a real concern. Like, I wonder if you'd have to get a waiver from the client, you being the state bar, the regulator, in order to do it. It's certainly a huge resource issue, but I do think there's a legitimate and widespread concern about licensing this new class of professionals, and are they going to be providing quality service? And we can't answer that question about attorneys now because we do not assess quality. This is the way that you would do it, right? Through seeing what's actually going on, which is really why you might ultimately want to be able to resource doing this randomly, a case file review, because then you're not just dependent on getting a complaint, you're just seeing what's going on out there. I
don't know, to me, random can easily cross over to arbitrary. How do you choose, is it by alphabet? Is it by area? Certainly, within the pilot phase, you could, as part of steps towards launching the program statewide, you could kind of build that in, because the number of cases will be more limited to only certain counties, right?
Mhm.
As a way of,
And then it becomes
evaluating
part
the
of the
program at the
evaluation.
pilot stage,
Yeah, it becomes part of the evaluation.
Right. And it's more manageable at that stage.
Right now, if you get a complaint and you want to look at the way Attorney X handled this case, are you allowed to get the entire, basically, file and case record without the client signing off? Or do you have to have client sign off to be able to get that record?
I don't know the answer to that, but I think because in general, we are opening complaints only in response to a complaint by a client, and that in opening that case for the client, there is some kind of process that allows us to have access. And I know, like in immigration cases, we have to get this other additional waiver in order to access the file, but I don't know, Randy, if you know the answer. You're on mute.
Maybe Brady might know a little bit more of how that works in the actual system.
I mean, because I know we have to do that, even if, if we get, for at least on the healing arts side, we have to have a sign off from the patient. We can't just walk out unless we have a subpoena and then be able to enforce that subpoena if they argue it. So, but again, it is medical records on that side. So I'm not sure if that's different than attorney-client records. I don't know, Amos, do you know?
Well, I can't imagine that anyone would be able to, an attorney or a paraprofessional would be able to disclose confidential files without a waiver, because they're not the holder of the privilege, it's the client. So, I just assume, I don't know the process that the state bar goes through, but I just imagine that there would need to be, in what we're contemplating here, need to be a client waiver or consent.
Yeah, so my basic thing was that understanding was that if a client complains, then by analogy, the system relies on 958 of the evidence code, that they've put something at issue, and the state bar can seek confidential information directly from the respondent lawyer, even though the client hasn't submitted a signed waiver or consent. The fact of the complaint against the lawyer puts at issue the representation and allows the state bar to require the attorney to respond. But if you don't have a client complaint, then you don't have any basis for saying that the representation, the communications, that representation should be available to the state bar, because nothing has been put at issue. It's not like in a fee dispute where client sues the lawyer for fees, and now the lawyer can disclose things about the representation to defend against fees. If the state bar is initiating everything, then I think, as you say, Agnes, the normal protections, confidentiality, privilege, all are, they just remain intact unless you change the law somehow.
Well, I think that's right. I think the privilege remains intact in either case. But I think you're right, the analysis is slightly different of the reason for the bar to make the request might be different. But in either case, I think the professional has the obligation to assert the client's privilege, and or at least give them an opportunity, whether or not, wherever the request is coming from, I think the privilege exists, and it's the client's privilege.
I see on our complaint form that you certify at the end that you're waiving the attorney-client privilege for the purposes of prosecution and investigation of the allegations. So that's the very last box that they sign on the complaint form.
What if like a judge made a complaint and you want, and said, I don't know if anybody knows this, but like a judge made a complaint and they wanted to look into the case. I guess you'd have to contact that client and see if they'd sign off on the waive their attorney privilege, which kind of causes a problem with us doing case file reviews, right? That's where you're going to run into it.
Yeah, especially doing it randomly.
Right.
If there's been no complaint. And even if there was a complaint and there's that waiver, on the complaint form, that's saying to look at my case. And to do a case file review, you kind of want to look at 20 cases or,
I mean, it's the regulatory agency. For a regulatory agency, that would be great, right? We have to say, I mean, that's how you would know how this person's doing, because a lot of people don't make complaints and you might not know that they don't have it, they're doing a poor job out there and not doing consumer protection.
Is there the potential for including among the disclosures that is it advisable to have potential clients sign a waiver to allow the regulator to waive the privilege for the regulator to do this kind of a case file review if it's part of the regular practice of the regulator? Do you see any issues with having that kind of a waiver?
So I think it's an interesting idea. I do think having a broad waiver of everybody who's using a paraprofessional is waiving their rights to confidentiality. I think that would be a problem. But maybe in connection with like a client survey, were you satisfied? And to the extent you're not satisfied, would you be open to, waiving your confidentiality and privilege rights for a potential file review? That might be an interesting way to go.
Okay, so what can we do to further the conversation? Should we get more information about this particular issue on privilege and confidentiality? Map out how case files reviews might be possible. I know that they do it in Australia, Victoria. They do case file reviews for estates trust attorneys.
They do it in Ontario also.
Are you looking at proactive regulation long-term? Would it be helpful to kind of divide into stages? Like what are we going to do after the pilot period? And then sit at the table again and think about long-term, if the program is even going to be launched long-term. You see what I mean? Because we have a pilot, I'm assuming, because we're really going to take a look afterwards and see if this is a good program to continue long-term. So I'm thinking we need to sort of divide this into manageable chunks. One for during the pilot phase, and then take a look at what worked and what didn't work, and then talk about a long-term process.
My understanding is that that's sort of not how we're characterizing the pilot. The pilot, I don't think, is characterized as we're launching it and going to see if it's going to continue. I think the pilot is more being seen as a phased implementation. So it's going to initially launch in certain areas, but it's not like it has a sunset. Obviously, if it turns out to be really disastrous, it wouldn't continue. But and correct me if I'm wrong, Leah, but I don't think that's how we're characterizing the pilot.
I don't think that it is either, but I do think Fariba's distinction is valuable, because what I think is accurate is the evaluation of the program is going to happen during the pilot phase. And so some of these things we may want as part of the evaluation, like for example, client feedback. Definitely want that. And the proactive regulation is, in contrast, something that would go on in perpetuity. Now, there might be some overlap because, for example, we may want client feedback, not just during an evaluation phase, but we want client feedback as part of ongoing regulation. Or if you all do decide to recommend a self-assessment, I think Tara Sklar's recommendation was after the first year of practice and after the third year of practice, it's mandatory. So the first year would certainly be within the pilot phase. So there's some potential overlap, but I think it's a nice way to think about, like, the initial data collection efforts are geared around an evaluation. The prospective data collection efforts are geared around proactive regulation. And maybe we try to keep them separate also as a way of reducing the burden placed on the licensee. We try to minimize the overlap.
So I 100% agree. So I think that's how we should be considering it in connection with the evaluation, because I 100% agree the evaluation should include not only client feedback, but some assessment of quality and competence and comparison to the, alternative, et cetera, et cetera. So evaluation of the program. And that's why I say it, when we were discussing it before, we hadn't yet discussed evaluation separately as a full working group, but it was clear that evaluation is going to require significant data collection to be meaningful, and it's going to be burdensome in some way or another. And so this does overlap. I think we definitely need to be collecting data on quality. And the question is that better in the evaluation? And if this is if this self-assessment or proactive regulation is different in terms of the data that is being collected or the purposes of the collection or what's going to be done with the data, we just have to really think that through, because I think it's important for this to be as part of the evaluation. And I'm not sure what added benefits we get in sort of doing it twice or doing it as under the proactive regulation banner.
Well,
So
the
it sounds like
added benefit is it's ongoing. It's ongoing. That's the added benefit. You have it over the duration of the program. It's sort of built into the infrastructure of regulating the program.
And so do you think the evaluation is just going to be a one-time evaluation during the initial pilot phase, and then there's not going to be continuing evaluation?
I don't think there would be, because we don't continually evaluate anything else, and it will be extremely expensive. So I just don't see, there might be another evaluation 5 years later once new program, once new practice areas have been added or something like that. But I don't see evaluation as like an ongoing activity, just because I don't think it's going to be feasible.
Leah, one quality evaluation technique that Professor Gillian Hatfield noted to both ADLS and then recently to CPJG was this whole so-called secret shopper methodology. And so it gets at the same type of quality evaluation that you would find in case files, but what you're sidestepping is the whole confidentiality privilege, having to go to an actual client, because the person who's the client is the secret shopper who's in there for the explicit purpose. I know it seems more like covert investigation type activity, but it's in there for the specific purpose of saying, well, I had a trust done by a lawyer. I also had a living trust done by the paraprofessional. We can look at both, have them reviewed by expert estate planning lawyers. And if the paraprofessional's work product is just as good or has the same deficiency or failure rate as lawyers, then you come out with hard data at the end saying, well, we checked for quality during the first year, the evaluative phase through secret shoppers. And, to the extent we were able to spot check certain tasks and delivery services, we found them to be, hopefully acceptable. But that would be expensive, employing secret shoppers to investigate in that fashion.
what may be effective, I mean, it reminds me of all that work that's been done on racial discrimination in interviewing and recruitments, right? When you send the same resume, the same cover letter with different names to different employers, or to the same employer, and you get an interview with, you know, if you submit one name versus an interview under the other name. So there's been a lot of that done. That's a lot less labor intensive than secret shopping an entire legal case, but it's very effective, very powerful data, I think.
And I think,
Personally, I would like to see us, oh, sorry, Fariba, go ahead. I was just going to say, personally, I would like to see us focus these efforts on supporting the new paraprofessionals in becoming competent and providing them resources and, you know, training opportunities and answering their questions, as opposed to, you know, burdensome or, you know, too heavy-handed. So that is at least my sense of what I'd like to see happen here. And that, again, I think the evaluation, however, is important and is going to be burdensome. So that's just what I have in mind. So I'd like, you know, to the extent there's additional resources, trainings, you know, testing is also another way. I just don't know if it's in the cards that we could do another test after the initial test. But, you know, what you're talking about is checking if they have the right substantive knowledge. And, you know, obviously that would be helpful, but I just don't know if it's appropriate or too burdensome to have, you know, secret shoppers or additional testing or additional required training. Again, we did that with MCLE. You know, we could do something like you were just talking about, Randy, with the first year of practice with attorneys. That's going to be very helpful. That's going to help with competence. We just have to think about the burden.
I think that's a really good point. I think that's, as I'm just kind of rethinking the conversation we've had and even the comments I've made, I feel like I look at negatives, like you know, how do we catch the bad actors? Which is certainly because I had a bad week here. So, but and that's an important aspect of, you know, program evaluation, I think, and proactive regulation. But I totally agree with Amos that, you know, we have to also focus on providing support and, you know, on the toolkit, all of that in terms of helping these new licensed professionals become, not only become competent, but also remain competent, right? I think at another comment I wanted to make was that during the pilot phase, I think it may be easier to get the pilot courts to come on board with some participation in program evaluation, because it is a pilot phase. It's, as long as I'm mandated, like invite them to participate. And we already had one meeting, and with the self-help centers in those counties. I'm not sure if the judges meeting has happened yet, but I think that the gist of that meeting was also that most self-help center participants, they had bad experiences. So to invite them to just, you know, submit comments, not only negative, but also when they see good work, I think it's important to also say that. So I want to mention the same thing with regards to collection of comments from clients, that it could be good feedback or bad feedback. I mean, both, at least in the pilot phase anyway. And it's not really to necessarily to connect to certain paraprofessionals, but also get a general idea of what's happening out there. Are most paraprofessionals good? Are most customers having positive experience? Are we really addressing access to justice issues? Are we really providing more access through this program? And I want to see that at least some sort of evaluation of, especially the access to justice piece at the end of the pilot program, that this really did provide more access. I have my doubts because of the whole, you know, the outcome of the in-court representation and then fee caps. But I like to have some hard data collected at the end of the pilot phase.
You know, one idea I'm sorry, this is just brainstorming out loud. I don't know if this really works, and it really is additional MCLE, I guess, but more advanced training. So my sense is the required training from the licensing subcommittee is going to get the minimum training that's required to get people competent, hopefully, and maybe more than that, but there's going to be, depending on the practice area, there's going to be a lot of stuff to cover, you know, in terms of substance and in terms of new practice and things like that. MCLE is designed for continuing education to keep people competent. But what I'm thinking about right now is more of an advanced curriculum, like, you know, the next stage. So it might be a seminar or a multi-day, or, you know, something akin to what the initial training is, but just, you know, more advanced or refreshers. So as opposed to like 1 hour bite-sized MCLE programs over lunch, just have, you know, a really, really thoughtful, advanced training for paraprofessionals to sort of, you know, again, boost confidence that people could take intentionally because they just want to, you know, learn more and get better trained. I think a lot of our experience with MCLE could serve that purpose, by the way. It's just that it doesn't always. And I think a lot of our experience with MCLEs is sort of get it done and, you know, what's available, when's the deadline and what lunch program, as opposed to it can be done, I think, in a way through MCLEs that's just really targeted advanced trainings.
Yeah, skill enhancement is totally valuable. I just, you know, for attorneys anyway, I mean, 35 units in 3 years, but you can't dictate, other than the categories, you can't dictate whether they take a 3-hour seminar or 1 hour here and 1 hour there, right? So would we,
right, but
is
we
your
could make
idea
it
to
available.
mandate it?
The idea is we could make it available, right? We could make it available and attractive as a way to meet your requirements and, you know, increase your competence and skill levels.
But this group already came up with their MCLE requirement that was voted on by the working group. And I thought it was a bit more prescriptive in terms of applicability of the MCLE. Do you remember what it said, Linda?
It was in the practice area.
Yeah,
It required training in the practice area.
More than what's required of attorneys right now. So if I'm understanding you, Amos, and sort of the general tenor, a lot of what you're talking about, Free, was evaluation. Like, we put a lot of emphasis on heavy, burdensome, expansive data collection during the evaluation phase, including client surveys, judicial stakeholder feedback, you know, which we've already sort of talked about, quality assessment, which could be done through case file review. It could be done through a secret shopper kind of paradigm, but a quality assessment component. And then for the ongoing proactive regulation, the emphasis is much more on supportive tools, which would also suggest that they would be voluntary. So even if one of the tools is, for example, a self-assessment, it would be voluntary potentially, the way we're going to roll it out for attorneys. So the ethics hotline, all of these are supportive tools. That's kind of where I'm hearing you.
So I think that's accurate. I mean, I think I have in mind that the evaluation is absolutely essential as part of rolling this out. I don't know that I had in mind that it would be a one-time shot and be done on evaluation. If that is the case, then I might have a different opinion going forward after the evaluation phase of you know, self-assessments, because then there wouldn't be, you know, it wouldn't be in addition to the data collection related to the evaluation. But yeah, I think that's exactly right. I don't know what the evaluation is going to look like right now, but I just think it's important and likely will require burdensome data collection.
And it seems like what we're talking about then is to reiterate that the proactive regulation, at least in the initial phase, is going to be supportive. And then depending on the outcome of the evaluation, additional proactive regulation can be developed that would potentially be mandatory.
And depending on whether or not the evaluation is going to be ongoing, which again, I don't, there's not a model for that I can think of, or a way to fund that, but that doesn't mean anything right now. That could certainly be the recommendation.
And Leah, it's obviously probably going to be a third-party evaluator, like organization that'll do.
Yeah, I'm losing you. I don't know if it's just me.
No, she's,
Okay.
my screen, she's
There we
frozen.
go.
Oh, there she is.
Okay, yeah.
All right. So it is going to be a third-party evaluator that's doing the evaluation for State Bar.
Well, I'm saying that now. I had thought that would probably be the working group's recommendation, but we don't have that kind of evaluation bandwidth internally, because we're talking about a very robust evaluation.
Yeah, my recommendation would be a third-party evaluation as well, but I couldn't tell from the last discussion. Yeah, that makes sense, but again, there's a funding issue because it is costly.
Yeah, and there's go ahead, Kim.
All right. The reason I was asking is because of that other, it just really has to be clear that this is like an evaluation of the program versus an individual that truly does want to submit like a complaint against, a licensee.
Mm-hmm.
I'll have to think about that.
Okay. So Linda, if I'm right, so that we've got, in terms of what's left for this subcommittee to address this issue, you're going to weigh in on the licensee name, but we have some more work to do on that before you can. The governance model, I think you've weighed in on, and Amos, we're going to make your change in terms of who appoints the hearing officers. So I think this is the last major issue. We've got the joint meeting with the discipline committee to talk about the disciplinary standards. We've got many more things going on here, but
There's two joint meetings with the discipline committee, one to revisit the UPL.
Okay.
And that's on the 12th, and the one on the 20th to look at the discipline standards.
Okay. So I'm wondering if what Linda and I are tasked with doing after our last meeting is coming up with more of a proposal for the evaluation framework. So I'm wondering if what would be helpful is for us to bring that forward. So then we can really start thinking about evaluation versus regulation, and it can be a little bit more concrete.
That sounds great.
Okay.
I do think most of the stuff that we're talking about with proactive regulation doesn't overlap. I think it's really just a self-evaluation and maybe file review.
And client survey.
And maybe client surveys. I would love there to be a continuing, client satisfaction survey. I think that would be wonderful. But yeah, I agree.
Yeah, and I think I'll ask for some internal brainstorming about the challenges with the state bar administering an ongoing client survey tool because of that potential confusion for the consumer, and when does it land on the complaint side. But I love the idea.
But how do we drive clients to that tool? I guess the paraprofessionals would be required to give all of their clients information about the survey and how to access it.
There'd be a link.
Yeah.
That would be provided, or a link on the paraprofessional website.
Okay.
Okay.
So, and in terms of, we have a meeting scheduled for next week. I know Amos can't be here, and I don't know if we'll be ready to bring forward the evaluation. So I'm not sure where we want to go with that. Do we want to have a meeting next week, or should we cancel next week's meeting?
It sounds like we can cancel. That'll give us 2 weeks to kind of do the legwork on this per our discussion today. And then, yeah.
Okay, I'll go ahead and cancel that meeting.
And then I might have a few cleanup issues. There's the, and I could probably even do this one now.
Okay.
We've talked, I've learned more about that MCLE rule we discussed last week, but I might have a few cleanup issues for, I guess, 2 weeks from today. And I'll have a better sense of how much time that would take next week, Linda.
Can I just clarify, the meeting on August 12th is a joint meeting with discipline regarding the UPL, is that right?
Yes.
And Amos, I sent around my notes with the recommendation, the suggested recommendations on that. And you're the person that asked for to have a meeting. So I'm going to be looking to you to articulate where you want to go with that. Most folks just indicated they were okay with those recommendations.
Okay, happy to. And I did try to do that with my email as well, but I can go back and look to see if there's any other suggestions. Can I ask about the name? Were there 3 names that you could share with us that are being considered, or is that we're still waiting on that?
I thought you shared those at the last meeting, Linda.
Well, at the last meeting, we had a discussion about what the concerns were about the name. And based on the discussion at last week's meeting, there were the top 3 names, and then there were a number of others, Amos, that you had suggested. We've sent those, I actually have sent those to the professional translators we use. I think I sent a total of 7 different names, and we are asking them to provide translations in the major languages that are used in California to get some feedback on that. The translations, variations on translations, and the potential problems each of those translations might raise. So that's, we're moving forward on that, and then we'll come back to the subcommittee with that information.
So based on that, we will eliminate names, right? If they present any issues, and then, if all 3 of the top names from the survey are eliminated, we're left with the names that you've recommended, but we did have to see what the translator says.
That's great. So I think what Justice Petru was saying is that her plan was likely to submit 3 names, not 1 name to the Board of Trustees, but that, before that's decided or done, we would have a chance to comment and provide feedback. So that sounds great.
Yeah, that's the plan. Okay.
All right, so we're going to cancel next week's meeting and see you on the 12th.
And then the 19th will be a regular meeting.
Yes.
Okay.
Okay, but Brady, was there something you wanted to cover now?
Sure, I could. And then, so this was just the discussion of State Bar Rule 2.86, which provided a procedure for getting MCLE credit for non-pre-approved events. And let me pull up my email from Bob McPhail. And in our initial discussions, the sense was that we didn't want to recommend a similar rule because we want closer control over the MCLE for this new program, and that there's no real identified need and the administrative burdens. And what I've learned from Bob McPhail, who's the person who handles these requests from attorneys, my guess is will lead you guys to solidify that conclusion. First of all, since last August 1st, we've gotten about 158 requests, the State Bar, from attorneys for MCLE credit for non-pre-approved activities, which isn't a lot given that there's 200,000 attorneys, but it does take quite a bit of time. He says that probably about 6 hours every week throughout the entire year is spent on those. The actual breakdown, though, about 20% of them come from non-California attorneys. So it's what I identified in my initial conversations with Araya, who oversees the whole process. And those are people who are working out of state and taking courses elsewhere that just obviously aren't CLE approved. But actually 80% are California lawyers. And what the source of those are, and this is actually the reason that this program was created, is for attorneys who need very specialized training to do their jobs. So the classic example is personal injury attorneys who need to take medical courses and sometimes courses on medical billing. So non-legal courses, but that are necessary for their particular practice. Apparently, the medical field is the reason that the rule was created, but it now comes up more with sort of intensive finance courses for attorneys working in business law, and some public law courses, because those are often geared toward government attorneys who don't have an MCLA requirement, so they don't go through the MCLA pre-approval process. But then some attorneys or opposing attorneys who have a need for those courses take those courses that are for government attorneys who don't need MCLA credit, and then they do, and so they submit. So, it sounds like the entire reason for having this program is for these specialized, highly specialized attorneys, which I don't think applies to the program that we're creating, and that it is a relatively large burden. It sounds like we grant most requests, but there's a lot of back and forth to figure out exactly what's going on. We don't necessarily give a one-for-one credit in terms of hours. They try and figure out which parts of this big course are actually necessary for your practice. So, consistent with our approach where we didn't, make a formal recommendation, if your sense is still that this isn't something that we want or need for the paralegal, I'll put together sort of a summary of these 6 to 8 areas and our general sense to, put forward in a resolution recommendation to the working group.
That sounds right to me. Thank you.
Ew, that's a lot of work for, yeah. I mean, I remember when you first brought it forward in June, I was just like, that is a lot of work for people who can read and try to just get it somewhere else, and they can take additional training. So
Yeah.
it's okay to have more.
And especially since here where we are more prescriptive in terms of what the courses are,
Yeah.
and these paraprofessionals are going to be more limited in the tasks they do, I just don't see the same need.
Agreed.
Okay, great. So that's one thing off the list.
All right. Anything else I'm going to try to get through in 8 minutes, Brady?
No.
Okay.
Okay.
All right.
I'm just sort of trying to make sure our bases are covered, and so I don't even know that I'll have anything to bring to you. But if I do, I'll let everyone know before the 19th.
Okay.
Thank you. Bye.
Bye.